Hello students, today we are going to study subject social science of class 9th, chapter 11, Indian Judiciary. See, in the previous chapter we read about the different organs of government, and in that we read about legislative and executive. Now in this chapter we are going to study about Indian judiciary. See, we all know judiciary is a system of court that interprets and applies the law in the state, and it also punishes the culprits. Now let us begin with the chapter Indian Judiciary. Chapter 11, Indian Judiciary. See, we have studied in detail about the two organs of government, that is the legislative and executive, in our previous chapter, chapter 10. And now what we shall study in detail about the third organ of the government, that is judiciary, which is the independent, statutory and impartial organ of the government. See, in this we are going to study about judiciary. And the Constitution of India provides for a systematic and organized and also the uniform judicial system throughout India. See, our judicial system is there. See, the Indian judiciary system is an independent as well as statutory or impartial organ of the government, and the power of the justice to people and to punish offender of the laws. And the Constitution of India, they has also made provisions to provide systematic and organized and uniform justice through the judiciary. And see, now in the Indian judiciary system, it is the form of a pyramid hierarchy. See, you can see a pyramid over here. First of all, we can see it's the Supreme Court, then comes the High Court, then district plus taluka court, and then the trial court and special courts. See, we have established a uniform judiciary, and in at the topmost level there is a Supreme Court. See, you can see at the topmost level there is a Supreme Court, and Supreme Court is also the apex court. At the middle level there is a High Court. See, in the middle there is a High Court, and under their jurisdictions of the district court, and at the district level and the taluka there is a local and special courts. See, apart from this there are trial courts and tribunals also, which are established to cater to various objectives. See, in this we can see in this structure that is in the form of a pyramidal structure. First of all, we can see that is a Supreme Court, and Supreme Court is also known as the apex court or the court of records, lies on the top of this pyramid, and the Supreme Court is the highest court of India. And next, this is the High Court. At the middle level are the High Courts. Majority all states have High Courts. And then the subordinate courts, that is the lower courts. See, all the courts below the High Courts, they are called subordinate courts, and the district courts are the first level court in subordinate court, and there are also other courts known as tribunals, that is the second level, or say that the district courts. Now we will see is the importance of judiciary. See, what are the importance of judiciary? A neutral and impartial judiciary is established in federal system for protection and preservation of the rights of the Indian citizen, and to solve any incongruity between the center and the state, or between one state and the other state regarding the division of workload. See, in the independence of judiciary, what is there? There is a neutral and impartial judiciary protects and they preserves the rights of the citizen. See, the judiciary, they help to solve the differences that is arising between the center and the states, or it is between one state or the other. And the judiciary does all the important tasks of interpreting constitutionality of the provisions given in the law. See, the judiciary is also an important organ that is to interpret constitutionality of and provisions of any law also. and so that the supremacy of the constitution prevails. See, by doing this, what happened, the judiciary sees that the constitution that is there, that remains supreme at any given point of time. So it is the supremacy of the constitution prevails in it. And in order that the legislature and the executive do not violate any of the constitutional limitations. See, an independent, firm, or impartial and a fearless judiciary is extremely important. Why? To see that the legislature or executive, they do not violate the constitution. And we require in a country independent, firm, impartial, fearless judiciary, which is the foundation of democracy. See, what are the foundation of the democracy? Is the independent, firm, impartial and fearless judiciary, which is there. And the objective of the constitution is to see that the judiciary process, there is no flaw or delay, and the citizens get quick, cheap and equal justice. See, in this what it happens, the constitution is there, and they see that the judicial processes, whatever is going on, is conducted without any mistake or delay, and that the citizen get quick, cheap and equal justice through it. And in the presence of alert legislature and executive, the judiciary would always remain active. But many a times, due to administrative inactiveness and irresponsibility of the executive and authoritativeness of the legislature, impartial, cognizant, that is having awareness of it, independent and fearless judiciary has shown judicial inactiveness. See, what are the limitations of judiciary? See, we can see that although we know that the judiciary remains active and impartial in presence of alert, when there is alert in legislature and executive, at times this may not be the case, sometimes it not be the case also, but sometimes due to inactiveness in the administration and responsibility of the executive and authoritative behavior. See, when there is inactiveness of what in the administration and also the responsibilities of executive and authoritative behavior of legislature, the judiciary may not be able to remain fearless, independent and impartial. See, they may not be able to remain fearless because of fearless, independent and impartial. See, if they ask you the question, write a note on importance of judiciary, so you can write all these things and also the limitations of judiciary. Now moving ahead, we'll see the apex. See, what apex court, that is Supreme Court. Supreme Court is at the apex of the Indian judiciary. See, it is said that it is a name, as the name suggests, the Supreme Court is the topmost or the apex court of the Indian judiciary. As per the Constitution of India, it is a topmost judicial organization, and it is situated in Delhi. See, where it is situated? In Delhi. All the civils and criminal courts of India have to work under the jurisdictions of Supreme Court. See, all the civil and criminal courts are there of India, they have to work under whom? Under the jurisdictions of what? Of the Supreme Court. And the Supreme Court consists of one Chief Justice and 28 additional judges. See, in the Supreme Court, what they consist of? One Chief Justice is there, and how many additional judges are there? 28. There are one Chief Justice, there is one Chief Justice and 28 additional judges. And the Chief Justice of Supreme Court is appointed by President of India. See, the President of India, he appoints the Chief Justice. And the number of judges in the Supreme Court is decided by the Parliament. But if the President feels that the workload of the Supreme Court is increased, then the President can adopt additional ad hoc judges to the Supreme Court. See, ad hoc means what? They are appointed by special procedure for a specific project or case or any period of time, to contrast to a regular judge. So, judge to the Supreme Court as the provisions to the Constitution. See, the President of India, he appoints the Chief Justice, and all the other judges, they are appointed by whom? By consulting the Justice as well as the other judges. And as per the norms, see, according to the norms, the parliament, he has a right to decide the total number of judges to be appointed in Supreme Court. And however, if the president feel, see what the president, he feels that the Supreme Court is overloaded, when he feels that Supreme Court is overloaded with the work, he can appoint additional ad hoc judge. See, in that he can, president can appoint the additional ad hoc judges on the basis of provision given to the constitution. Except for the Chief Justice of the Supreme Court, all the other judges are appointed in consultations with the Chief Justice as well as the other senior judges. See, a judge of the Supreme Court now is appointed on the basis of his seniority only. And see, the court and the except of this Chief Justice, see, justice, the judgment given by the Supreme Court, that is final and it cannot be changed anywhere. See, everyone has to need to follow it, and the procedure of Supreme Court is also carried out in English language. See, it is said, see here what is said, the Chief Justice of Supreme Court, all the other judges are there, they are appointed in consultations, when they have been consultation with the other Chief Justice or as the senior judges with them. Now let us see the qualification. See, a person who is appointed as a judge of Supreme Court should be, see what type of qualification should be there for a judge of a Supreme Court. First of all, he should be a citizen of India. Second thing is, he should have provided any service at least for how many? 5 years, where in a judge in any of High Court or in India. Or third thing is, he should have an experience of at least how many years? 10 years as an advocate in any High Court of the India. See, he should be provided any service in the High Court of India judge as a judge for 5 years, or he should have at least experience of 10 years as an advocate of High Court. Or fourth thing is, he should be distinguished, he should be a distinguished judge or a famous jurist. He should be a famous also, and he should be different from the other judge as per the opinion of the president. And the fifth one is, he should not be more than 65 years of age. He should not be more than how many years? 65 years of age. Why? Because thus the retirement age is 65 years for the judges of Supreme Court. See, the retirement age is how much? 65 years for the judges of Supreme Court. Now let us see the time period. See, what are the time period? See, the retirement age is 65 years of the judges of Supreme Court. See, we have seen that at the age of 65 years, the Supreme Court judge retires. However, the change in the age of retirement can be made by the Parliament through framing a law. See, the changes of the age of retirement, that can be made by whom? By the Parliament while they are framing the laws. And see, a citizen of India, that is below, he should be of 65 years and retirement of is of 61, and should see all these qualifications should be there. And generally the judges of the Supreme Court, they can work up to 65 years of age, and however his retirement age can be extended by whom? By the Parliament only. And they cannot carry the practice of the law in any of the Indian court, but they can provide their service in the committees appointed to the investigate into uncommon situation or event. See, during their tenure, this ages, these judges, they cannot practice in any court. However, they can provide their service where in the committees appointed to investigate some special cases. If incapable to carry out their duties before the time of retirement, then under such circumstances they can resign willingly from their post by tendering written resignation to the president. See, if the judge wishes to resign from his post, he can do so by what? By submitting a written resignation letter to the president. And and but the judges can be removed from their post and powers if they are found to be guilty of incapability, misconduct, or inefficiency. See, if the judge is found guilty or is incapable or inefficient or is involved in some misconduct, he can be removed from his post through a procedure called impeachment. See, this removal of in accordance with provisions of constitution, that is carried out through impeachment motion in parliament. Through impeachment be they can removed from the post. The procedure for it is as of the follows. See, what are the procedures of the impeachment of the Supreme Court is as every house of parliament has to submit a memorandum having majority support to the president of the total number of the members and at least two-third number of the member present in the respective session. See what is said over here. The process of removing the Supreme Court judge from his post in case of if he is found any guilty or incapable, insufficient, or he is involved in any some kind of misconduct, that is called, we all know, that is called impeachment of the Supreme Court judge. And the process through the process of impeachment is conducted in the parliament. And see, the house of the parliament in which the case is charged initiates the process by taking the consent of the majority of the total number. See, of whom, of the majority of total number, and how many, two-third member present and voting in each session. And based on the presentation by the order of president, the judge can be removed from his post. See, the other houses of parliament, they studies and inquires the charges, and the houses of the parliament monitors the presentations made through memorandum regarding the charges that is against the judge. The house also investigate the proof for the same, and on the based of what, on the inquiry and the proof, the impeachment motion it is put for vote. And if this impeachment motion is passed by the majority votes of the parliament, then the president removes the judge from his post. The parliament monitors the presentation of a memorandum regarding the misbehavior of the judge, and it is conduct an investigation that is being carried out through the proof for the same. And in this way, the majority that gives the opportunity to present and narrate the self-defense in the parliament. See, the President of India administered the oath of secrecy and loyalty towards the Constitution to the judge who appoints to the Supreme Court. And before taking the charge of their post, and judges are required to take a oath in oral as well as sign the pledge. See what is over there in the process of oath of secrecy of Supreme Court is done, that before the Supreme Court judge takes a charge of his post, he need to take the oath of secrecy and the loyalty towards whom, towards the Constitution in oral, and then he signs the pledge. And the president of India, he administers the oath that the judges takes. Now in the next part we will see the power and jurisdiction of Supreme Court. Thank you.